Okay, so today we're sort of combining two principles that we learned about federalism and judicial review, putting them together to get a big picture perspective on the evolution of our Constitution. So federalism, the division of power between two governments, central government and a state government. Federalism allows for states to maintain their diversity, their popular sovereignty. It relieves the federal government of the burden of handling everything. Federalism can work out great, but often this division of power or this overlap of power leaves a lot of things in question, and that's what most politics is about. When we do have questions about what the Constitution says, we can go to our referee, that would be the Supreme Court, which does have the power to determine the constitutionality of a governmental action. So I have a lecture reiterating things we've learned in the past, introducing a couple new concepts, and then you will explore 4 cases and answer some questions on those cases to further see the evolution of federalism and how the Supreme Court has answered questions as they arise. Okay, so you've seen this chart before. This is the way our Constitution gets formally amended. So we know that the document can change over time with the addition of amendments, but that is very difficult to do. There's only 27 amendments. This document has remained rather thin. It's not too lengthy. Then you've also learned in the past few classes how it continues to live and evolve and change in informal ways through basic legislation. So Congress, in making laws, essentially adds flesh to this skeleton. Congress can augment its power, building off of what's in the Constitution. Custom, how things have been done over time, also sort of adds to what we view as constitutional in this country, or at least constitutionally accepted for so long that it's not questioned. The president's power in the executive branch, the second article of the Constitution about executive power is rather short, so it leaves the president some wiggle room, just like Congress has wiggle room on what their powers are. Party practices, there was never an intention to support a party system, but because we have freedom of speech, freedom to assemble, parties have formed, and the way that they operate is crucial to the rest of how politics and government operate. So party practices also contribute to the way our Constitution has evolved. And then finally, judicial review, that the Supreme Court can review a case, determine the constitutionality or the lack thereof of something, and determine what the document says. That might change over time. Okay, so I want to focus on a few parts of the Constitution, pause this video as needed. But the enumerated powers, those are the powers Congress has, that the federal government has in Article 1, Section 8. And at the end of it, we have the elastic clause, the part that says, and Congress can do whatever else is necessary and proper for carrying out these other powers listed in Article 1, Section 8. So the enumerated powers is a really long list of what the government can do. And then in Article 1, Section 9, you have a smaller list of what Congress can't do. So the Constitution delineates congressional power, really giving this Congress under this new Constitution more power than the Congress under the Articles had. Article 1, Section 10, the denied powers, these are things the states can't do. So states can't coin money, states can't enter into war or negotiate treaties with other countries. Basic things that the states can't do. So what I want to do is point out the vague area, the not mentioned area. So the 10th Amendment, known as the Reserved Powers or the States' Rights Amendment, I do want you to read it, pause this and read it. And what you'll see is the language might feel tricky at first because it is rather short. It says the power is not delegated to the U.S. by the Constitution. That means given. Delegated means given. So the power is not given to the federal government, to the U.S. by the Constitution. The list of powers is in Article 1, Section 8. And the powers not prohibited by it to the states are then left to the states respectively. So the 10th Amendment kind of translates to, if it's not on the Article 1, Section 8 list, and it's not on the Article 1, Section 10 list, then leave it to the states. So another name for the 10th Amendment is the reserved powers, powers being reserved to the states, and the States' Rights Amendment. But then you also have the Supremacy Clause. That's Article 6, the second paragraph. So pause this as you go to it and read it. And what you'll see here is that, in a sense, the federal government reigns supreme. When we say Supremacy Clause, this Constitution and the laws made by the federal government, when they come into conflict with the state government, would be supreme. So what about all the things that are in between these two? The 10th Amendment is short. It tells us that these are the reserved powers, or the States' Rights Amendment, but nowhere does it actually say what are those powers. And that is because of the potentiality. These powers are potentially endless. So if it's not something Congress can do, then it is left to the states. For example, nowhere in the document is there mention of public education. Congress does not have the power to establish a public educational school system. It's not in Article 1, Section 8. It's also, schools aren't mentioned in Article 1, Section 10 as something states can't do. So since it's not something the federal government can do, can regulate, and it's also not something that the states can't deal with, education is a reserved power to the states. So potentially infinite list of things that the states can do, but when the states come into conflict with the federal law, the Supremacy Clause sort of asserts that it would be the federal government that is supreme. So you can imagine there's a whole slew of topics that aren't in Article 1, Section 8, not mentioned in Article 1, Section 10. So the tension becomes which government has responsibility in this arena, which government has power in this arena, and then, how it affects you as the citizen. So which government does what? When we do have a question, the Supreme Court sometimes answers it. Remember, the Supreme Court has the power of judicial review. They can tell us what's constitutional and what isn't. That means that the Supreme Court answers a question, and that usually stands for a long time, but the Supreme Court can even change its own ruling in another case. An example of this would be Plessy v. Ferguson. In that case, the Supreme Court said segregation in rail cars is constitutional because things can be separate so long as they're equal. That was the separate but equal doctrine. And in that case, the Supreme Court said that that is equal protection of laws. Being separate doesn't mean that it isn't equal. Well, if you started to look around in the South particularly, but across the country wherever there was segregation, things didn't look so equal. Things didn't look just separate but equal. They looked separate and also, not so equal. So by 1954, the Supreme Court takes a case again about segregation in schools, but this time it says, no, separate but equal does not stand. That does not adhere to the Equal Protections Clause of the 14th Amendment. So the court has a lot of power in its rulings, and it can even change its own mind. Now, the members of the court in 1954 were not the same members in 1996, but the idea is the institution can even reverse its own decisions. So thinking about how justices do their job, they have, you could argue, two schools of thought. Granted, many people are probably in the middle. But two schools of thought about how you use your power if you are a judge. You have the school of thought that you should, as a judge, be a referee, not a player. That you use the Constitution, you read the Constitution, you stick to the original intent of the framers. It's up to Congress and the President to make laws and enforce those laws, but your job is to keep those two branches in line with this document. So someone who adheres to the school of judicial restraint would say the Supreme Court should really be quite strict in its reading, quite literal in its reading of the Constitution. This is kind of like how strict constructionists in Congress would say, stick to what's in Article 1, Section 8. Don't focus too much on the elastic clause. Be really cautious about expanding congressional power. Judicial activism is the other side. That's the idea that you have the power in the court to make decisions that will promote desirable social ends. And a judicial activist would say that that is what you should do with your power. The Supreme Court has the power to read this, and the elastic clause is there for a reason, so that this document could evolve with the times. So they would say that, you can read between the lines a good amount. In order to maintain this document, it has to be flexible, malleable with the times. So, two schools of thought. I don't want you to think of these as Republican or Democrat or liberal conservative, because you'll notice that when it comes to how an individual justice thinks, they tend to sometimes follow judicial restraint when it suits their ideology, and other times follow judicial activism when it suits their ideology then. So most judges are on this spectrum and can move depending on what the topic is, and not stick strictly to one side or the other. So an early case that I want to go over briefly, pause this if I'm going too fast, is McCulloch v. Maryland. The question in this case had to do with Congress having a national bank and then the state of Maryland wanting to tax the bank. So there were two questions. Can Congress have a bank? Can Maryland tax it? Yes, Congress can have a bank. And the Supreme Court said Congress can do that because it is implied that they have the power to charter a bank. But every implied power, if you recall, has to come from an expressed power. And McCulloch v. Maryland said the second paragraph of the enumerated powers, the power to borrow money, allows Congress to have a national bank. But that term, implied powers, that was born in the McCulloch v. Maryland case. So I've already talked about expressed versus implied powers, but I want to make sure you know that that whole doctrine of implied powers is established in McCulloch v. Maryland in 1819. So it is not something that, it's not really a term that came to be as accepted until this case, that Congress has implied powers. So this opens a door for Congress to make a lot of laws, because the Supreme Court has said that's what the necessary and proper clause does. It gives you implied powers. So yes, you can have a national bank. Now, to answer the question about can Maryland tax the bank, the Supreme Court said no, because no state can tax a national entity, and they looked to the supremacy clause. And this use of the supremacy clause establishes the doctrine of national supremacy. So why this is a significant case in 1819 is it uses two doctrines that we referenced today, the doctrine of implied powers, the doctrine of national supremacy, but it really opens the gate to strengthen federal authority protected by the Supreme Court ruling, and to potentially give Congress, that branch, a large power in this new government. Another case shortly thereafter, Gibbons v. Ogden. I'm not going to go into the details, lack of time, you can look it up. But this question came down to the Commerce Clause. And what we saw was the federal government, by way of the Commerce Clause, could regulate waterways within a state. Okay, so we think about waterways within a state, that would be intrastate. But in this case, the Supreme Court said even intrastate affects the economy outward. So by way of the third clause of the enumerated powers, Congress can regulate interstate commerce. And so this would open the gates for that third clause to be the most widely used or most widely abused clause of the enumerated powers. That is the clause that allowed Congress to ban discrimination in public places in 1964. That is the clause used to justify a federal minimum wage. So this is like the beginning of that Pandora's box of using the Commerce Clause to augment federal power over state power. So in the next one, I'm going to explain the activity you're doing.